the process that the defense undertook. It was completely valid. It was standard in cases like this. Dr. Edelman is an expert in this field, and he has done this jury research and this work for 15 years. Nothing about the format, the methodology, the questions, or the fact of the survey itself was wrong. You've talked about 2 questions that you are describing as false because they're not in the affidavit. But if you look at that affidavit and what the media has done with those things is they have created a narrative based on the facts that are represented in the affidavit. Now, I would agree that there's a lot of information in that affidavit that is just flat and not true. But if we focus on where we are right now, there are representations in the affidavit about multiple trips to Moscow from Pullman and a return trip to Moscow from Pullman in the morning that lead a reader to the word of stalking, that you have a problem with that word being included. Reflect back on the case law in the United States Supreme Court about showing false information, but also look at that affidavit and the way the media has construed that in its representations, in its reporting that is so prejudicial. Because the basis for this spin, the foundation is right there in what you are describing as the public record. Now, I fundamentally disagree that the only public record in this case is what's there on the 12-page docket. The public record in this case that the entire nation, the world, and looking at, and especially Latah County, is derived and construed out of that public record.
So can I ask you a question about that? This public record thing is really kind of circling around, because what's the purpose then of the non-dissemination order? If everything out there in the public is the public record.
Well, my understanding, Your Honor, is that it's the one of the primary issues was the credibility of the person that is out there speaking. We did not want law enforcement, 159 officers out there talking about police reports and disseminating that. We didn't want the prosecutor doing press conferences like we saw on 12/30/2022. We didn't want the defense getting up and doing press conferences based on the information, because we have information that no one else has, and we are consulting with experts that the public doesn't know about. And so we have a level of credibility that the others don't have. And so that is my understanding of what we're trying to get a hold of. And it's been pretty effective in this case until this valid survey that happens in high profile cases has been construed to be something nefarious, which it absolutely is not. As you've heard, it's been used in Boston bombing, the Parkland shooting, the Colorado theater, George Floyd, hundreds of cases going back decades. Dr. Edelman's declaration and now his testimony are uncontroverted evidence before this court on this issue. It's the actual evidence that the court, and finally today, you're getting informed about the validity and the science behind the process. Nothing that was done is worth the hysteria and the hyperbole that keeps getting expressed in this courtroom. The questions asked, the topics, the order, the open-ended, the specifics, they were all done using information that is out there for everyone to see. And the research methods used to determine what was out there is the traditional way and the scientific method that experts in this field use, just as Dr. Edelman testified. And to be sure, the purpose of this is to give you information so that you can make an informed decision about venue. It's not for a nefarious purpose. It's to arm you with facts and information so that you can apply the United States Supreme cases that have been adopted in Idaho and determine whether or not there's presumed prejudice. You know, when we first started talking about whether or not there was going to be this venue hearing sooner rather than later, Ms. Batey for the state said at least 3 times, Judge, they can't just come in here with affidavits. This case law says that they have to have more. The more that we are gathering to provide you, at least part of it, is this survey. In terms of the proposition that this survey taints the jury pool, first of all, you heard from Dr. Edelman that if someone answers they don't know, a second question tapping into that is asked, and the process stops. There's no other questions other than demographics because they don't want to poison anybody who doesn't know. So for there to be this proposition that all of these questions, these 9 questions that are later on in the process, were put out there intentionally to poison the jury pool, that's just flat false. And the other point is you can't taint what's tainted. When you hear what the statistics are as it relates to this county, 97% of the people had familiarity with the case. 79% of the people knew 5 or more prejudicial and false media reports. 81% of those who had heard about the stalking had determined and took a position that Mr. Kohberger is guilty. These people that were surveyed didn't form the opinion when they were being surveyed. And they didn't then go research their already strongly held opinion because of the survey. These are deeply held opinions in this community within this jury pool. The Latah County citizens have accepted the information placed before them by state actors. It's not just Mr. Thompson that did a media report and talked about the probable cause affidavit. Chief Fry, the coroner Kathy Mabbitt. We've got search warrants from Pennsylvania out there in the public record. We've got hundreds of search warrants in the public record out there from Idaho. We've got all kinds of pleadings. This is all information that's put out into the media. And having the state now claim this moral high ground is an oxymoron. It's a complete oxymoron for state actors to put this information out in the public and now say, hey, wait, if you want to ask if people have believed the information that we put out there, you can't do that. That harms Mr. Kohberger. We as a defense team have the obligation and frankly the privilege of defending Mr. Kohberger and defending his right to a fair trial. And in doing so, in arguing that venue should be changed, we have to show you that there is presumed prejudice in this community. And since we have the burden of this, and you now know essentially from this expert that there is presumed prejudice in Latah County, you have to ask yourself, do you want more information to know where the better venue is? And that takes me to the next point, which is what we cannot do. You've heard Dr. Edelman say that it goes outside of his standard of practice and the scientific method that has been used for decades, that has been used in hundreds of cases to take your ideas about what should be in questions, to take the state's ideas about what's being in questions, should be in questions in the survey. He follows a process. That's the process that he needs to follow because he has to provide the court with apples to apples comparison. Another issue that has was addressed last week that I want to touch upon, and there are two, is this concept that if we just done a juror questionnaire, it would have addressed all of that.